the chief legal officer of Ripple, Stuart Alderoty made a bold comparison in a social media post comparing the U.S. Securities and Exchange Commission chair, Gary Gensler, to a fictional character, Colonel Nathan Roy Jessup from Aaron Sorkin's critically acclaimed play A Few Good Men. Alderoty draws parallels between Gensler and Cole Jessup, implying that both are resistant to change and dislike confrontation. The Ripple CLO has recently criticized Gensler for his behavior in court in interviews and during his appearances before Parliament. Allegations of opacity, criticism from government auditors, secret meetings, and a dwindling worldwide influence are just a few of Gensler's controversial personality traits that Alderoty brought to light. The SEIC's relationship with the virtual industry is becoming increasingly strained, which is why this criticism is timely. Until Congress lays out clear restrictions, Representative Tom Emmer has suggested that the SEC limit its power over cryptocurrencies. Gensler, like the unwavering character of Cole Jessup, is prepared to meet crypto proponents, but he maintains his steadfast position. Accusations that Gensler was accumulating power while Americans' financial options were being eroded were leveled against him during his recent hearing before the House Financial Services Committee. Regardless, Gensler compared the present scenario to the pre-regulatory era of the 1920s and emphasized the necessity for nuanced compliance in the cryptocurrency industry, defending the SEC's impartial approach to technology. The legitimacy of Ripple's secondary sales of XRP is the primary concern of the SEC in this case, rather than whether or not XRP should be classified as a securities. This method emphasizes that the SCLA is more concerned with the purported infractions of Ripple than with the broader categorization of XRP as a securities. This dispute between Ripple and the SEC has become a focal point for larger discussions regarding the regulation and future of digital assets, which is relevant given the ever-changing regulatory and legal environment around cryptocurrencies. In response to the SEC's request for financial statements, Ripple has fired back. This is the official SEC document that accuses Ripple and two of its executives of running an unregistered security offering for more than $13 billion. Ripple and the U.S. Securities and Exchange Commission have denied the sect's demands. Ripple responded to the request to compel certain post-complaint discovery late on January 19. In the XRP dispute, Ripple's legal team has been arguing that the SEC's reasoning is illogical and has been urging Judge Torres to rule in their favor. The Securities and Exchange Commission requested that Ripple submit audited financial statements for 2022 and 2023, as well as details regarding XRP sales contracts with non-employee counterparties and the total amount of XRP obtained from institutional sales following the filing. Conversely, Ripple gave two reasons for turning down the start request. There is no good cause to conduct additional discovery on sales made after the complaint was filed, as the Securities and Exchange Commission did not initiate discovery during the present fact discovery period. The idea that discovery made after a complaint was relevant to potential remedies was never explored by the Securities and Exchange Commission. Rather, it ruled that everything done after the complaint was totally irrelevant to the matter at hand. According to Ripple's reasoning, the motion was settled after he provided his approval. On a second point, the court's remedy judgment is unaffected by the SEC's irrelevant demands. If the SEC wants to know if Ripple did anything illegal after the complaint, it will have to wait for a long fact discovery phase or start afresh with litigation. Specifically, the Securities and Exchange Commission has asked every question it has regarding this subject and cannot ask any further questions on its own. If any discovery made after the lawsuit is found to be irrelevant, Ripple is asking the court to disregard it. A rule released in July 2023 is the basis for the SEC's decision to compel, according to a previous piece by Coinbase. Selling XRP coins to large financial institutions constitutes the sale of securities, according to that opinion. Whale activity hit a 15-month high, while the price of Bitcoin made a small recovery. Attorneys contend that the finding has no bearing on the matter at hand. Jeremy Hogan, an attorney representing the SEC, said that the agency is currently dealing with a relatively small discovery issue and is asking her to issue an order requiring Ripple to provide financial statements for 2022 and 2023 and post-complaint contracts regulating institutional sales. In July 2023, the commission issued a rule regarding XRP, and the contracts pertaining to institutional sales were a part of that ruling. In order to help Judge Torres decide whether to impose injunctions or civil penalties on Ripple, the Securities and Exchange Commission has requested this narrowly focused discovery. The amount of the penalties is stated in the filings. Ripple has been found liable for violating Section 5 of the Securities Act. On January 11, court listener Ripple asked for an extra 2 days until January 19th to respond to the Securities and Exchange Commission's motion to compel instead of January 17. Changes in the cryptocurrency landscape are predicted by Ripple executives for 2024, claiming to have obtained funds through the use of unregistered securities. The Securities and Exchange Commission began legal action against Ripple, its CEO Brad Garlinghouse, and its executive chair Chris Larsen in December 2020. October 2023 saw the commission's submission of a notice signaling its intention to discontinue the case against Garlinghouse and Larsen, but it would keep pressing the company on the issue. The trial that Ripple is expected to undergo with the SEC is scheduled to begin in April. The commission has taken enforcement procedures against prominent U.S. Bitcoin exchanges like Binance and Coinbase. Stuart Alderoty, who is the chief legal officer of Ripple, has called the Securities and Exchange Commission an out-of-control regulator due of the SEC's uninspiring legal stance on Bitcoin. Apart from this, he reads the Section's 2020 Grand Press release that was produced at the time of the lawsuit's filing, and it shows that the SEC is losing control of the laws. The request was allegedly related to a July court ruling that said XRP may only be sold to institutional investors in order to be designated a security according to the commission. Ripple has been asked by the Securities and Exchange Commission to provide financial accounts by way of a court order. The United States Securities and Exchange Commission's legal team has asked a federal judge to order Ripple to hand over records related to the ongoing enforcement case. He petitioned Judge Sarah Netburn of the U.S. District Court for the Southern District of New York on behalf of the Securities and Exchange Commission on January 11. In the past few days, the Web3 Trade native token has been making headlines because to its spectacular climb throughout the pre-sale rounds. This has caused XRP and Polkadot, two cryptocurrencies, to lose investors. Experts have speculated that crypto holders are struggling to weather price swings and losses in addition to the benefits of holding XRP. Since the XRP court case seeks to distinguish between ordinary investors and sophisticated investors, it is not contributing significantly to the token status. So as to not lose money, XRP holders are selling off their tokens. Why? Because no one can say for sure what the verdict will be. According to the XRP market analysis, the coin is underperforming in terms of market value. The market value of XRP is reported by 0.67% in the last day after climbing almost 5.6% in the previous 7 days. Despite a drop, XRP is still worth $30.8 billion, putting it in sixth place among cryptocurrency market capitalizations. It is believed that Polka will be one of the cryptocurrency market's major players in Q1. However, the cryptocurrency is struggling to meet the goals that analysts have predicted it will achieve by the year's end in 2023, despite its origins in an attempt to solve the scalability issues caused by blockchain technology. The alternative coin Polka seems to have lost steam. That's all for now.